to know, Alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Monday, May 19th. Let's jump right in. First up on the stand was Nick Bradford. He's a DNA expert with Bode Technologies, and he goes through the DNA that he tested. As for the hair, they transfer that to the mitochondrial department. As far as the DNA on the passenger side taillight, there was a mixture of 3 individuals. John could not be excluded, and the likelihood ratio, it was John's hair, was 740 nonillion times more likely to be John than a random stranger. Buchanan and Proctor, there was strong support for excluding them as the other 2 contributors. On cross, for Proctor, the number that the witness gave was 1 in 76,000 that it would not be Proctor. So the defense says you're not suggesting he's completely excluded. The witness says no, but there is strong support for exclusion. And the witness was not asked to compare the DNA to Brian Higgins, Brian Albert, Kevin Albert, or Kenneth Berkowitz. The next witness was from Bode Technology again. John could not be excluded as the source of the hair sample, but 99% of the population could be excluded as the source of that hair. On cross, the defense says mitochondrial DNA is only from mother to child for a male like John. If his mother had 2 children, John and his sister would have that same mitochondrial DNA, and her own children would have that same mitochondrial DNA? The answer is yes. The defense says, so that doesn't mean the hair you're examining had to come from John. The witness says no, it could be from anybody with maternal lineage. And that was it for this witness. Next up was Shanon Burgess. He does accident reconstruction from a company called Aperture, and he started this case in October of 2024. He got raw data as well as photos of the SUV. There was an attempt to download the modules from the SUV, and he had read a report from someone named Maggie Gaffney, who initially tried to download information from the car back in December of 2023. He reviewed crash reports from the Massachusetts State Police, Trooper Garino's testimony, Ian Whiffin's report, as well as surveillance video. He was specifically looking for user data in a raw format or a file system where user data is stored. He focused on specific timestamps, ignition power on events, and other data. The 2 events that he focused on was the 3-point turn maneuver and the backing maneuver, and he put together a PowerPoint presentation. He explains the modules and what information they provide. The infotainment center, and the telematics. The telematics systems use GPS sensors as well as onboard diagnostics to gather data about vehicle location, speed, fuel consumption, driver behavior, and more. He also looked at airbag control and body control modules. He looked for triggering events, and when this happens, there's certain data that's recorded for a specific time frame. And he looked for one in this case, when the car is powered on and the clock starts to run. He discovered there was a computer chip on one of the computer boards that was never examined. The previous analysis damaged the chip while removing them. His initial impression was that there was data that was missed from the initial download, which was all of the user data, or it could be a partial read of the chip. The data on the chip is locked, and accessing the data without having a passcode is very difficult. He tested this method on a similar vehicle to Karen's to make sure it would work. The reason is they wanted to create a known data set. They connected cameras inside the car, looking from the back seat into the front seat. They wanted to record any interactions the witness had with that car. They can then compare the data to their times of when they did certain things to do their own testing. The software versions in the test car and Karen's were the same. They were looking for mainly time-stamped data for ignition on events for the morning of January 29th. They found when he pressed the ignition on button, a logo appeared on the screen. And that time is associated with the time in the raw data. But it shows a date and time in UTC time and an identifier that the car has been powered on. The ignition on would be 3 seconds before the infotainment system powers on. What he was essentially showing is the first power on event was at 12:36 a.m., and that would be the time when John and Karen left the Waterfall Bar. And after that event, the car was powered off at 12:42 and 8 seconds in the morning on the 29th. They validate the accuracy of that power on event to surveillance video with timestamps, which shows the consistency of his results to surveillance videos. It was accurate to the second to their reference clock. The next power on event for Karen's SUV is 5:07 and 46 seconds. That's when she is leaving John's residence that morning. It's powered off at 5:46 and 20 seconds. They confirmed the time was accurate by lining up these times with surveillance of her leaving and arriving back at John's house. He again says the timestamps on the videos are accurate to the data that he found. As far as Karen traveling to the Dighton residence, the power on event was 12:35 p.m. and it ended at 2:12 p.m. They again compare surveillance video for that ending event. The next power on event for the SUV was at 4:11 p.m., ending a minute later at 4:12. This is when they're loading the SUV onto the tow truck. The next power on event was 5:34 p.m., and it was powered off at 5:36 p.m. This is the time when the SUV was brought from the tow truck into the Sally Port at the police station. That was the last event for January 29th. He compared these times to the iPhone. He explains that these times are not synced and it can vary up to 60 seconds. The next two events he looked at was the 3-point turn as well as the backing up maneuver. To reconcile this time difference between the SUV and John's phone times, he needed an event that both clocks record at the same time. At first, he didn't initially try to sync the clocks because they can vary by up to 60 seconds. He said he became aware of a claim by a defense witness of an attempt to sync the clocks, but he says he found the error in John's iPhone when the 3-point turn happened. He wanted to further his study of the 3-point turn and the backing maneuver, and in doing so, he found a claim of the attempt to synchronize the two clocks as misleading. If there's two devices recording a similar event, they can compare that to the time recorded on the Lexus versus John's iPhone. The SUV had the 3-point turn happening at 12:23 and 38 seconds in the morning. John's phone had the 3-point turn time as 12:23 and 59 seconds a.m. through 12:24 and 7 seconds a.m. The witness said that falls within the 60-second time variance expected between the phone and the car's clocks. The difference is between 21 and 29 seconds. So he said they would need to add 29 seconds to the SUV's clock to have it match John's phone. Next, he looked at the time of the backing maneuver of the SUV. He applied that time difference and found the backing of the SUV occurred during a window of 12:32 and 4 seconds to 12:32 and 12 seconds. He compared that to another event on John's iPhone when the phone was locked at 12:32 and 9 seconds. On cross, the defense comes out and says, you called this case a homicide before you began your alleged scientific testing, but the witness does not recall saying that. Then the defense says he has a public profile on the Aperture webpage that has his education listed. And on that, it says he has a bachelor's in mathematics and business administration. The witness admits he does not currently have this degree. Aperture has 2 hyperlinks to his CV and also to his LinkedIn profile. And the defense says this is to show potential clients like the Commonwealth of Massachusetts your credentials. Were you notified within the last 72 hours someone from the defense viewed your public LinkedIn account? He says no. What about in the last 72 hours? The hyperlink on Aperture's website has been disabled. He is not aware of that. He doesn't know if someone within Aperture was asked to disable his LinkedIn account. He says he's never spoken with anybody at Aperture about disabling that LinkedIn. So the defense shows him the LinkedIn profile. He admits the degree he states he has on his LinkedIn profile, he does not. He has listed on that public profile that he got his degree between 2016 and 2018. The witness said that LinkedIn profile is years old and it hasn't been updated in quite some time. The witness says that's what it states, but there's a number of errors in that. The defense says there is no degree with that name at the University of Alabama, Birmingham. The witness says that's one of the errors he just didn't find. The witness does have an associate's degree he obtained in 2015. The defense says, do you recall when you started pursuing a Bachelor of Science? And the witness says 2008. The defense says you've been pursuing this for 17 years and you haven't obtained it as you sit here today. But we've seen documents that say you have. The witness says with errors and misinterpretation. The defense asks if he is familiar with the phrase academic dishonesty. Yes. They go on about this for, it seems like half of the cross, and we're not going to go through every single thing that was said. Let's get down to the meat of what they questioned him on as far as his reports. They talk about in October of 2024, the Commonwealth hired the witness, and in the report, you outlined a proposal to attempt to extract additional data from the infotainment center and the telematics. And in that, you explain why, in your opinion, you believed an additional data acquisition was necessary based on your education, training, and background. You had access to the chips in question, and you were under no deadline. In your October 10th report, you thought the data acquisition was incomplete because, in your opinion, the download of an acquisition was less than the chip's storage capacity. And converting megabytes to megabits and gigabytes to gigabits is a basic digital forensic concept, which is critical to successful data acquisition and analysis. In your initial report, you said the December 2023 data acquisition, which was from the spansion clip, was incomplete because the acquisition was only 8 megabytes in size, even though the chip can hold 64 megabytes. The witness agrees. Defense, you blamed the programmer's inability to fully read the component closed book, but the manufacturer's specifications say the total flash memory components of the chips in question is 64 megabits, not 64 megabytes. That means the chip was not incomplete, and the witness agrees. Defense, your protocol for data acquisition was based on a misunderstanding of megabits and megabytes. The witness said it was based on a working theory and his own misinterpretation. Defense, you mentioned Ms. Gaffney in your direct testimony. She successfully acquired 8 megabytes of data from that chip. Yes. Defense, that wasn't your only conversion mistake in your October 2024 report. The witness said he's not aware of any other mistakes. The defense names off some very technical stuff and says the acquisition was incomplete, and he points out other errors in the witness's report. The defense says that would indicate all the data was successfully retrieved on this chip by Ms. Gaffney, and she was not in error on that. The witness said not on that specific thing, no. Defense, it was you who misunderstood megabits and megabytes. The witness says misinterpreted, not misunderstood, but he admits he did make an error. The defense asked if his work was peer reviewed by anyone at Aperture, and the witness says no. Also, no supervisor review. The defense says the entire foundation of your proposal was a misunderstanding of a computer bit and a computer byte. The witness said not the entire thing. Defense, you got conversions wrong when analyzing three different chips, and the witness says that's correct. Defense, since you wrote that, have you learned the difference between a bit and a byte? And the witness says he's always known the difference. Defense, you learned that in this case from reading the affidavit of an expert from the defense who pointed out those errors before you submitted your supplemental report. The witness said he would have to go back to look at the timing, but he thinks he submitted the supplemental before the other expert. The defense asked if he's certain of that, and he's not. The witness agrees he got no additional data of value from the previously examined computer chip by Ms. Gaffney and admits she did not miss anything of value. He's asked if he reviewed a CARS report that was done by Trooper Paul. And do you know what a CARS report is? The witness does not. That is a collision analysis and reconstruction report. The defense says you testified about John's phone extensively, and the witness says just location data. They bring in a document that contains location data. He said that he reviewed Trooper Garino's testimony from Karen's first trial for specific data. The defense says that's not really science and data, it's testimony. So did you review testimony beyond science and data? And the witness says, yes, it's common. He said he skimmed the testimony for information about the infotainment and telematics modules. He says he's only interested in those two modules. The defense asked if he considered that testimony for anything he did in this case, and he said no. They move on, and the witness says Lieutenant Tully brought him the infotainment and telematics module so that the witness could attempt to reinstall those in Karen's SUV. And that was on December 7th of 2024. He tried to reconnect the infotainment module to the faceplate and then reinstalled the infotainment and telematics module. He did the same testing on that separate vehicle that Aperture purchased, which is similar to Karen's car. With Karen's car, he was not able to reinstall and test the telematics system. He was able to get the infotainment backlight and faceplate to illuminate, but in his own words, the infotainment system did not respond as expected. So he took the micro SD card itself to try and get data off the card directly. But Lexus locks their cards, and this testing had never been done on this kind of car before. The defense points out there's no scientific literature that states the methodology the witness used. The witness says there is literature that addresses it in other ways, but not specific to this Lexus. The witness finished his first report on January 30th, 2025, and the defense says that report included a general timeline analysis of where he said it could impact event reconstruction. The defense says the witness's report included a general timeline analysis, but it doesn't discuss collision, and the witness says no. They go back and forth about whether or not he used the word collision in that January 30th, 2025 initial report. The witness said he believes it does in the background portion. He looks at his report and says, I apologize. The word that he actually used was incident and not collision. The defense says his first report doesn't refer to the timing of what you call a text stream event. No. In your January 2025 report, you refer to it as an incident. And in your May 8th report, it's a text stream event. The witness said that would be referring to two different things, but he did not use that language in the January report. His conclusions were limited in the January 2025 report to generally identifying what he calls a clock skew between the infotainment center and John's phone. He did not perform any additional analysis to determine if the text stream event occurred, and he's asked why not. He said he wasn't asked to. He was asked to look at the general timeline and the consistency of the timestamps. When they say text stream, it's really one of the two events, and they use numbers for these events, which would be the 3-point turn and then the backing up. The defense asked, wasn't your goal on January 30th of this year to determine the correct timeline events related to this event? The witness said he was asked to determine the data from the infotainment and telematics modules that were missed in the initial download, and then to create a timeline and consistency of those timestamps. The defense says that timeline, among other uses, was for your colleague, Dr. Judson Welcher, to use in his analysis. So you knew your purpose, but also what your work would be used for by Dr. Welcher. The witness said he knew that his work would be provided to Dr. Welcher, his colleague. The defense asks if the witness ever discussed this case with Dr. Welcher. He said a handful of times. They talked about the witness identifying what he found on the modules and explaining that data to him. He's asked, did Dr. Welcher ever tell you why he wanted to use that data? The witness said for reconstructing a timeline. The defense says you knew for the text stream event he was going to use your analysis to try and pinpoint that event. The witness says yes. Defense, and you knew he used that to select a specific range for that event? The witness said what he's doing is identifying the time the event would have occurred. Defense, isn't Dr. Welcher's work on the events an important aspect of the work of Aperture on this case? Yes. The defense asked if the Commonwealth asked him in his January 30th, 2025 report to not discuss his work in connection with the events. No. The defense says, but you didn't discuss these events in your first report, but you did, and heavily, in your May 8th, 2025 report. The witness says yes. The defense points out that report came out in the middle of the trial, which started on April 22nd, and the witness agrees. The defense says the initial report you mentioned nothing about these two events. The trial starts April 22nd. Then you prepare another report on May 8th. You enlarge the number for the range. It's bigger than your first report. The witness said he did not change the number. The defense says, let's go back. You said on direct, you prepared the May 8th report on your own initiative, but that report opens with a letter. Dear Mr. Brennan, pursuant to your request, I've completed an additional analysis concerning the above referenced manner to formulate opinions. The following additional items were reviewed. The defense says this wasn't done on your own initiative. You did this at the request of Mr. Brennan. The witness disagrees and says it was done on his own initiative. He says the pursuant to your request line that the defense read out was a cut and paste from a previous report. The defense asks if he reviews what he cuts and pastes, and the witness says yes, but he didn't think this was significant. He's asked, why did you do an additional report? And the witness said there was a PowerPoint by the defense expert of trying to adjust clock syncs or making clock adjustments that was produced in March. And the witness's initial thought was just to address it in testimony. But as he was preparing for trial, he decided it needed to be addressed in a supplemental report. The defense asked if he knows the defense's expert report was done in March, and you had this report you say was the basis for your own submission of a new report, and you waited 2 months. You issued your new report in May that changed your analysis, and the witness said no, it didn't. He said there were clarifications to his original analysis. The defense says in the January 30th report, you did not mention the events at all. You didn't mention a collision, but it's there in your May 8th report. The witness said it's not a change, it is a supplement. Who did you speak to regarding the May 8th report before you prepared it? And the witness says nobody. He did it on his own. Any communication with Tully or Buchanan? The witness said he did reach out to Tully to get the full set of the location data. Defense says, so you reached out to Tully before your May 8th report. Did he tell you the trial had started? The witness says no, not during that conversation. He's asked how many conversations he has had with Tully, and he said 5 to 10. The defense asked, is Tully an expert in this field? And the witness said no. The reason he reached out to him was to get information. Did you have any discussions from the May 8th report with anyone from the DA's office? And the witness says yes. On May 7th, he reached out to Mr. Brennan. The defense says that's before May 8th. He asked what the discussion was about. The witnesses about the data and what the report said. The defense asked, how many times have you submitted a supplemental report in the middle of a trial? The witness says this is the only time he's done it in 10 years. He's asked if he knows Ian Whiffen and familiar with his work. Ian Whiffen testified early on in the trial about the phone data. The witness said he's familiar with his name and also his report in the case. The witness was not aware Ian had testified earlier in the trial. The defense says that Whiffen has put out 2 reports with minor differences. They contain information about John's cell phone and location data, information about phone calls, the battery temperature, timelines in the report, and those timelines have very specific events that are represented in the data from John's phone, like location data and times you have used in your report and your PowerPoint here. He's asked, when did you get Whiffen's cell phone report? The witness said sometime in January. Defense points out 4 months ago. You had that report with substantial information about the data from John's phone, such as GPS location. You testified you know about cell phones and you have certifications in cell phones. You can use Celebrite and Axiom, and you've applied those tools frequently. And all that information you had back in January of 2025? Yes. Do you recall on your direct testimony, one of the reasons you did the supplemental on May 8th is because you got new or more information about John's cell phone? You had that information through Mr. Whiffen's report in January, which is 4 months ago. Yet you still submitted a report on May 8th in the middle of this trial? The witness says correct. The defense asks if he knows someone named Jessica who is working for the Commonwealth and if she's issued reports. He has heard of the witness, but has not read her reports. The witness denies watching or learning of testimony in this trial or the Commonwealth telling him anything about prior expert testimony. The defense says that Ian Whiffen's report contains statements about movements and other activity of John's phone after your time period in your January report. The witness says not after the time period, no. They point out his colleague, Dr. Welcher, says the infotainment trigger occurred at 12:31 and 28 seconds and ended at 12:31 and 43 seconds. But Mr. Whiffen's report from John's phone data showed a device lock at 12:32:09, and that was user initiated by pressing the side button. The witness said that time is according to the iPhone clock, meaning it hadn't been adjusted. The defense says, but that's what's in Dr. Welcher's report. Do you know the iPhone data reported by Mr. Whiffen that you read and Welcher references says there was an end of a health event, which were steps equaling 84 feet that ended at 12:32 and 16 seconds, which is after 12:32 and 14 seconds. The witness says yes, with the caveat that those clocks had not been adjusted. They end this with the defense asking if he is familiar with a pocket state from an iPhone. The witness says he is through reading Mr. Whiffen's report. Defense says, Ian Whiffen states there was a pocket state detected at 12:33 and 14 seconds. Are you familiar that Mr. Whiffen has put in the report that you read a timestamp for detecting a pocket state? The witness said seeing a report would refresh his recollection, and that is where we end the day. That's it for today. Hope you guys have a good rest of your evening. We will see you soon.